Welcome to Discourse Politics, everybody, your place for political and social commentary. I just did a video on the Texas filing against all the swing states. It was a broad overview, and now I want to focus on each and every state. So this is what Texas is claiming that the Commonwealth of Pennsylvania did that was in violation of the Constitution, which then therefore hurt their citizens because we are all electing a president. So first and foremost, it sets out the idea that there is a difference of 81,597 votes approximately between President Donald Trump and Vice President Biden. And what they claim below is a number of votes that are affected by the various constitutional violations, and it exceeds 81,597 votes. Pennsylvania's Secretary of State, Kathy Boockvar, without legislative approval, unilaterally abrogated several Pennsylvania statutes requiring signature verification for absentee or mail-in ballots, and it was not ratified by the Pennsylvania legislature, and it does not include a severability clause. So what they're talking about is Act 77, and Act 77 does not have a severability clause, which is really important. In most contracts and in most laws, there is what's called a severability clause, and what that clause is that let's say you have 6 points in a law, or 6 things in a law, or 6 things in a contract that you have to follow. What a severability clause does is if one of those things is deemed unconstitutional or unlawful in the case of a contract, then the rest of the contract or the rest of the law still holds true. Let's say in a contract, you're supposed to mow your neighbor's lawn, you're supposed to, repair his car, and you're also his or her personal slave for the next 2 years, right? The first 2 parts of that contract are actually enforceable by law. You can mow their lawn for 2 years, and you have a contract to mow their lawn for 2 years. You have a contract to fix their car for the next 2 years, but you cannot have a contract that actually gives away your human rights, in theory. Let's just say it's unconstitutional, because it might actually be constitutional. I don't know. If you saw 50 Shades of Grey, actually, it might be legal. Actually, I think it is illegal to give away your rights. Anyway, my point is that if you have a contract that stipulates those 3 things, if there's a severability clause inside that contract, what would happen is if you went to court and said you want to get out of the contract because it was illegal for you to give up your own human rights, what the court would do is look at that and say, that is correct, you cannot give up your own human rights, therefore that part of the contract is null and void. But because there's a severability clause, the other 2 parts are still going to be enforced, which means you have to mow your neighbor's lawn and you have to fix their car. So that's in a nutshell what severability clause is. It doesn't exist in Act 77, so that means that if any part of Act 77 is deemed unconstitutional, it would actually nullify the entire act, which is, like I said, it's bad law writing. There should always be a severability clause, but maybe that they did it on purpose because they hoped the whole thing would be unconstitutional. August 7th, 2020, the League of Women Voters of Pennsylvania, they filed a complaint with Secretary Boockvar about signature verification. And what happened was the Secretary of State quickly settled with the plaintiffs, and she issued a revised guidance. And what it says is, the Pennsylvania Election Code does not authorize the County Board of Elections to set aside return absentee or mail-in ballots based solely on signature analysis by the County Board of Elections. That goes counter to the law of the land. So this guidance is contrary to Pennsylvania law. The Pennsylvania Election Code mandates that it shall be signed by the applicant. And then it goes on to state that signature verification requirements are expressly set forth, and it gives the statute for which it says by how a signature is supposed to be verified. So the Secretary of State does not have the authority to change what the legislature set forth as the requirements for a signature verification in order for a mail-in ballot to be counted. The Pennsylvania Department of State's guidance unconstitutionally did away with Pennsylvania's statutory signature verification requirements. And the issue is that 70% of the requests were by Democrats and 25% from the Republicans. So it was to the detriment of Donald Trump and to the benefit of Vice President Biden. It goes on to state that Pennsylvania's legislature enacted bipartisan election reforms that set, inter alia means it's Latin for among other things. So it set, among other things, a deadline. So there was a deadline, among other things, of 8 p.m. on Election Day for a county board of elections to receive a mail-in ballot. The Pennsylvania Supreme Court extended that deadline to 3 days after Election Day and adopted a presumption that even non-postmarked ballots were presumptively timely, which again flies in the face of at least the law, or at least the spirit of the law, and it may actually be enumerated and they just didn't put it here. Pennsylvania's election law requires that poll watchers be granted access to the opening, counting, and recording of absentee ballots. Now, we went over a video a couple of videos ago of people actually pulling ballots out from under a table and counting them. And people were saying that, well, that's debunked because you don't have to have poll watchers there. That's actually not true. Poll watchers are granted access and they're supposed to be there during the counting. All those people out there are saying these things are debunked. I'll probably actually maybe even do a video about fake debunking, because that's what a lot of this is. It's fake debunking and then a lot of gaslighting saying, well, you're wrong because that's been debunked. I assure you, most of the stuff they say has been debunked is not actually debunked. They just say it's not true. There's a difference between saying, well, I believe that that's not true versus that's been debunked. So anyway, moving on. So prior to the election, the Secretary Boockvar sent an email to local election officials urging them to provide opportunities for various persons, including political parties, to contact voters to cure defective mail-in ballots. This process clearly violated several provisions of the election code. The first code is that they shall safely keep the ballots in sealed or locked containers until they are to be canvassed by the County Board of Elections. And then Section 3146.8G 1.1 provides that the first look at the ballots shall be no earlier than 7 o'clock a.m. on Election Day. In other words, in order for them to know that the ballots needed to be cured, they had to actually look at the ballots and sift through the ballots. So that was actually against the law as well. No one should have known that these ballots needed to be cured until they went to actually go and count these ballots. By removing the ballots for examination prior to 7 o'clock a.m. on Election Day, Secretary Boockvar created a system whereby local officials could review ballots without the proper announcements, observation, and security. This entire scheme, I don't like that word. Typically, in a legal brief, you don't want to use inflammatory words. Scheme, I don't know. Maybe it's inflammatory, maybe it's not in a legal precedent or legal terms. But to me, it sounds like they should have just said this entire unlawful operation would have probably been a better way to put that. But anyway, this entire scheme, which was only followed in Democratic majority counties, was blatantly illegal in that it permitted the illegal removal of ballots from their locked containers prematurely. And then it goes on to say that this violated Pennsylvania's election code and adopted the differential standards favoring voters in Philadelphia and Allegheny counties with the intent to favor former Vice President Joe Biden. Absentee and mail-in ballots in Pennsylvania were thus evaluated under an illegal standard regarding signature verification, or lack thereof. There really was no signature verification, or at least, according to Secretary of State, they couldn't deny ballots based on signature verification, which goes again against Act 77, which was set by the state legislature, which had the authority to set these things. So because they laxed their standards for disregarding the signature verification, now it is impossible to determine which ballots were properly cast and which ballots were not. In other words, the only time to actually verify signatures has to be at the time that you open ballots. And so when a ballot is opened and a signature verification is called into question, it has to be fixed right there or set aside. The Secretary of State made a unilateral move to not allow people to challenge based upon signatures. Then those ballots were then separated from their envelope, which was the only way for them to verify signatures, because you don't have signatures on ballots. You have it on the secure envelope. Once you separate the ballot from the envelope, you have no way to verify whether or not that was a valid signature and a valid vote. So what happened is this resulted in an unknown number of ballots being treated in an unconstitutional manner inconsistent with Pennsylvania statute, specifically Act 77. So then it goes on to say a great number of ballots were received after the deadline. They did not segregate the ballots. We know that for a fact. So the ones that were received after 8 p.m. on November 3rd, 2020, Secretary of State claimed that only about 10,000 ballots were received after this deadline. That's the problem. Only about. That has no way to be proven because they broke its promise to the court to segregate ballots and commingled perhaps tens or even hundreds of thousands of illegal late ballots. So on December 4th, 2020, they had a hearing which resulted in what was called the Ryan Report. And what this report says is that the general election of 2020 in Pennsylvania was fraught with inconsistencies, documented irregularities, and improprieties associated with mail-in balloting, pre-canvassing, and canvassing that the reliability of the mail-in votes in the Commonwealth of Pennsylvania is impossible to rely upon. So ballots with no mailed date. There were 9,005 ballots with no mailed date. What is in the records is that 58,221 ballots have a return date that is before the mail date. It may show in the system mailed on October 15th, returned on October 14th, which makes absolutely no sense whatsoever. And then magically, ballots that were returned one day after the mail date. So in other words, it was mailed on October 15th and returned on October 16th. That equaled 51,200. Now I can assure you the mail does not move that fast. No, it's not possible. And the reason is because when you do bulk shipping and bulk mailing, there is absolutely almost zero chance that bulk mail will end up in your mailbox the next day. Now, if it did end up in their mailbox the next day, it is possible that a person could fill it out and stick it in a ballot box, a sanctioned ballot box. And if they did that, it would be possible to have a one-day turnaround. So I'm not discounting this, but at the same time, it's pretty unbelievable that people would return it one day after it was supposedly mailed, because the odds of it actually hitting their mailbox is almost zero. And then the odds of them filling it out the moment they got it and putting it in a ballot box the same day is also almost zero. These nonsensical numbers alone amount to 118,426 ballots and exceeds Mr. Biden's margin of 81,660 votes. These discrepancies pale in comparison to data concerning the number of mail-in ballots distributed to the populace, now with no longer subject to legislated mandated signature verification requirements. On November 4th, 2020, the Commonwealth's PA open data sites reported over 3.1 mail-in ballots sent out. The CSV file from the state on November 4th depicts 3.1 million mail-in ballots sent out. But on November 2nd, the information was provided that only 2.7 million ballots had been sent out. The discrepancy of approximately 400,000 ballots from November 2nd to November 4th has not been explained. Really, what it comes down to is these stunning figures illustrate the out-of-control nature of Pennsylvania's mail-in balloting scheme. Once again, they use that word. I wouldn't use that word. Democrats submitted mail-in ballots at more than 2 times the rate of Republicans. This number of constitutionally tainted ballots far exceeds the 81,660 votes that separate the two candidates. The blatant disregard of statutory law renders all mail-in ballots constitutionally tainted. It doesn't say that they're necessarily invalid, but it says that they're tainted and cannot form the basis for appointing certifying presidential electors to the Electoral College. It's not saying that all of the votes are necessarily invalid, although it kind of is in a roundabout way. It's saying that this process was so tainted, this process was so bad, that there's no good way in good conscience that Pennsylvania's electors can be sent to the Electoral College and for their votes to count because of how bad and how unfair their system was, according to not only their own state law, but just compared to other states that followed the law and followed their own state law and followed the Constitution. In 2016, Pennsylvania received 266,000 mail-in ballots, and 0.95% of those were rejected. However, in 2020, 10 times that number were mailed in, and they had less rejection than in 2016. And the reason there was less rejection was because they did away with Pennsylvania's signature verification requirements. They extended the deadline to 3 days after the election, and they adopted a presumption that even non-postmarked ballots were presumptively timely, blocking poll watchers in Philadelphia and Allegheny counties in violation of state law. These non-legislative modifications to Pennsylvania election rules appear to have generated an outcome determinative number of unlawful ballots that were cast in Pennsylvania. Regardless of the number of such ballots, the non-legislative changes to the election rules violated the Electors Clause. So that, in a nutshell, is what happened in the state of Pennsylvania. And so therefore, Texas is saying that because Pennsylvania so grossly violated their own state laws and ran roughshod over their own state legislatures, which are constitutionally mandated to have complete and autonomous control over the way and the means with which electors are chosen, then you could therefore come to the conclusion that the electors from the state of Pennsylvania are tainted at best and should not be sent to the Electoral College. And if they are sent to the Electoral College, their electors' votes should not count because the process was so tainted and so unconstitutional. That is what Texas is claiming against Pennsylvania. For my next video, I will be doing the state of Georgia. And as you can tell, I'm kind of getting excited because this is what I've been waiting for. I've been waiting for the legal cases. I wanted to see the legal cases that made sense. And so far, Texas versus all the swing states makes the most sense. And we're going through them state by state. So that was the state of Pennsylvania. My next video will be the state of Georgia. Thanks for watching. Like and share. Make sure you subscribe, and I will see you next video.